Hi, and welcome to the third video in the employment module. This video is going to take a look at workplace injuries, dismissals, and justice involvement. We'll cover how you can help a client who says they were hurt at work. Then we'll take a look at how you can help a client who's been fired or laid off. Finally, we'll wrap up by taking a look at how criminal charges or time in custody can impact your client's job and what you can do to help. Let's start by taking a look at workplace injuries. Most people who are injured at work or because of work will be able to get money from the Workplace Safety and Insurance Board, also known as WSIB. There are some workplaces in Ontario that aren't covered by WSIB, but that's limited to only a few industries. Money from WSIB can help support your client financially if they aren't able to work, but it can also help them with other things like medical bills or other expenses related to their injury. But what counts as an injury? There are lots of things that could be considered an injury for the sake of a WSIB claim. It could be something organic, like a broken arm, or something non-organic, like PTSD. It can also involve secondary injuries, like someone becoming depressed after injuring themselves and not being able to work. These types of secondary conditions are important to keep in mind because the extent of an injury isn't always clear at the beginning. Things can change, progress, or become worse over time. And some injuries might also just come up gradually, like getting carpal tunnel from typing. There are a few things you can keep in mind though if your client isn't sure whether their injury will qualify. The first is that just because an injury doesn't require an emergency room visit, doesn't mean that it isn't considered an injury according to WSIB. Second, just because your client spends time in custody doesn't mean that they don't qualify for WSIB. Third, just because the injury didn't happen at work doesn't mean that it didn't happen because of their job. Fourth, just because your client has a pre-existing condition doesn't mean that they won't qualify for WSIB. And finally, even if your client was injured by somebody else at work, it doesn't mean that they won't be eligible. You can also let them know that WSIB works through a no-fault system. This means that even if they were doing something that they were told not to do when they were injured, they can still make a claim. The role that they played in that injury could impact their claim, but it doesn't make them ineligible. If a client tells you that they've been injured or if they're talking to you about an injury, it's helpful to ask where the injury happened. If it happened at work or because of work, you should ask them whether they told their employer or union representative about it. If they haven't, you should remind them to do it as soon as possible. The next thing that you can do is help your client get medical care. Not only is this important for their injury, but medical evidence is also critical for most claims, and your client will need to tell the medical professional that they've had a workplace injury. You can also help your client put together important documents, like medical records or expenses, and suggest that they also make their own notes of the accident. This should include notes about what, where, and when it happened, as well as who was there. If they spoke with their employer or union representative after, they should make notes of those conversations too. It's important to start taking these steps as early as possible because WSIB has a tight timeline for reporting injuries, and your client will only have 6 months from the date of their injury or diagnosis to make the claim. Some employers might tell your clients that they won't be covered by WSIB, or that your client is an independent contractor and therefore doesn't qualify, but their employer doesn't get to make that determination. WSIB will let your client know whether or not their employer does or should have coverage, and they'll also let them know if they're an independent contractor or not. This is why it's important your client makes a claim to WSIB, even if their employer tries to talk them out of it or offers to pay them additional wages instead. Making a claim is also important in case your client's injury gets worse later on, or if they have unexpected costs come up. So you should always remind them about the importance of making a WSIB claim, unless they're being paid in cash, in which case they should seek legal advice before submitting a claim. Now let's take a look at dismissals and how you can help a client who's been fired or laid off. If a client tells you that they were fired or laid off from their job, the first thing that you should do is refer them for legal advice. When someone is fired or laid off, there are different legal remedies that might be available to them, but timing can be critical, so it's important that they get legal advice as soon as possible. Typically, when an employer wants to fire or lay someone off, they'll need to give that person sufficient notice or sufficient pay. But what's considered sufficient in the circumstances will depend on the specific person and their specific employment situation. There are some cases where an employer can fire someone without notice or pay, like if the employee steals from the employer or if they have excessive and unjustifiable absences. but for the most part, employers can't just fire or lay someone off unexpectedly. Even if your client's employer gave them a reason for it, it doesn't mean that it was a good enough reason. This is why getting legal advice early is so important. Your client can get legal advice from the Law Society Referral Service, the Pro Bono Ontario Hotline, the Workers' Health and Safety Clinic, or their local legal clinic if it deals with employment issues. Another thing you can do is help your client keep records or documents related to their employment, like pay stubs, their employment contract, tax documents, or other relevant things like memos and emails. You should also help them make notes of anything that they do to find a new job, for example, getting help from an employment agency, or looking at job postings. You can also help them source other forms of income while they look for another job or wait to hear back about their claim, including applying for employment insurance or Ontario Works. They could also experience other issues if they aren't receiving a paycheck, and you can flag these for them too. This can include things like not having enough rent money, not being able to pay their support payments, or not being able to pay important bills. Finally, let's take a look at how criminal charges or incarceration can impact your client's employment. The first thing to keep in mind is that if your client is charged while they aren't at work or on their personal time, they're under no obligation to tell their employer about the charges. If your client does decide to tell their employer, or if their employer finds out another way, they could try to fire them because of it. So if this happens, you should tell your client to get legal advice immediately. Even though employers can in some very limited cases use employees' criminal charges to fire them, for the most part, alleged off-duty misconduct isn't enough on its own to fire someone without notice or without pay. If your client is charged and taken into custody, they might also be at risk of losing their job. But in the same way that off-duty criminal charges alone aren't usually enough to fire someone, the fact that an employee spent time in custody isn't always enough of a reason to fire them either. So if your client is fired because of their time spent in custody, you should refer them for legal advice immediately. If they're still in custody, they can get legal advice from the Law Society's crisis line. When they speak with that legal service provider, make sure that your client flags their employment issues. Non-criminal issues aren't always obvious in the middle of a criminal legal crisis, and they'll need to explain the situation to their provider. If your client hasn't been fired but is in custody and is worried that they might be fired if they're absent from work, you can help them contact their employer to discuss some options to keep their job. If your client's fired because of a criminal charge or because of time spent in custody, they might also have issues qualifying for employment insurance, but that doesn't mean that they shouldn't apply for it, or to Ontario Works to make sure that they have enough money to get by. This is especially important if your client is pressing bills or debts that they won't be able to pay because of the job loss. If they won't be able to make these payments, they could be at risk of creating additional civil legal issues, and you can help them look for additional funding where possible, or help them get legal advice if they won't be able to make the payments. And just like that, we've wrapped up injuries, dismissals, and justice involvement. Until next time.